is Beth Wright. I'm a professor in criminal justice, and I'm going to talk to you guys briefly about the American criminal court system and why it's so important for you to know that as civic individuals in your communities. All right, and there may be a little pop quiz at some point, so be prepared to talk. So our American criminal court system is predicated on the concept of federalism. Anybody want to give a gander to what federalism is? All right. So federalism is a system of government in which power is shared between a national government and state governments. Okay, so that's going to set you up for understanding how our court system or systems actually operate. We have a separate federal system, court system, and a separate state court system. So I'm going to talk you through both of those things, but we're going to start at the state level since that's the most likely place that you might be involved. There are 4 basic levels to state court systems. The very first or lowest level is called the trial courts of limited jurisdiction. These courts handle misdemeanors and lawsuits, so we're talking criminal law and civil law, and they include, for the most part, municipal courts, which is traffic and code violations, local ordinance violations, things that you could get a ticket for, essentially. General sessions courts, they hear misdemeanors and they hear the preliminary hearings for criminal felony cases. And juvenile courts. We have a separate juvenile court system, and that handles cases involving juveniles. That's looking at delinquency cases, so violations of law, status offenses. Status offenses are only things that juveniles can be tried for, like running away, truancy, underage drinking, things like that. Abuse and neglect, which is not something you're going to see in the adult system. These are people or kids who are in need of our services, need assistance because they're being harmed. You can also have child in need and state dependency cases. Again, these are where the court system is the place where they're going to get all the services that they need, potentially, maybe not everything, but it's going to be the place that those things are determined. The next level is probably what you're most familiar with from seeing on TV, trial courts of general jurisdiction. So think of law and order. 4 different types of courts here primarily. You got your circuit courts, and in circuit court you hear civil and criminal cases, and then you can hear appeals from those lower courts. You got criminal courts. This is going to occur kind of in concert with circuit court. They're going to hear criminal cases when there's heavy caseload. So think about Nashville, Memphis, Knoxville, Chattanooga. They'll have both circuit and criminal courts that are going to handle criminal court cases. Chancery courts, which is something we pulled on over from England, and they're going to deal mostly with civil cases, lawsuits amongst people, and then probate courts. In Tennessee, I think we have 2 probate courts. They deal with wills and trusts, estates, guardianships, and conservatorships. Okay, 2 more levels in the state court system. If a convicted offender does not like how their case turned out, or a civil offender doesn't like how their case turned out, either side in a civil case, they can appeal their case to a court of appeals. We have a specific court of criminal appeals where all those cases where a defendant was found guilty, didn't like it, thought that there was a violation of law or a constitutional violation, they can appeal their case, either the sentence, or really the sentence, up, or the finding itself up to the Court of Criminal Appeals. Civil cases can go to a Court of Appeals as well, and they have a whole bench of judges that will listen to that. Finally, if a convicted offender feels that the Intermediate Court of Appeals also found wrongly, perhaps that conviction was upheld or the sentence was upheld, they can go all the way up to the state Supreme Court and they can appeal their case, okay? Civil and criminal cases can be heard at the state Supreme Court level, all right? So it's not just limited to criminal cases. Their job is to interpret laws and the implementation, I guess, it's not the right word, but it's all I can think of the Constitution. Okay. In the federal court, it's a very similar kind of process, but they only have basically 3 levels. You got your U.S. district courts, which are the trial courts. That's where a case is going to be heard. But they hear more than criminal cases. They hear bankruptcy, U.S. Constitution, or cases in which the U.S. Constitution has been violated, cases involving laws and treaties of the U.S., cases involving ambassadors and public ministers, disputes between two or more states, habeas corpus issues, which means bring the body to me, and then violations of federal criminal court law. Okay, so it operates like a circuit court at the state level. That's the trial court. All right, so you've got presentation of evidence, you've got cross-examination of witnesses, expert testimony, and then there's a determination of guilt or innocence, or not guilty, because sometimes innocence doesn't always mean that they're not guilty of a crime, it just means legally they're not guilty of a crime. They also have a U.S. Court of Appeals. This is often the last word in thousands of federal cases. So if you're appealing your case in federal court, it's going to go right there. They review the procedures and decisions in the trial court to make sure that the proceedings were fair and that the proper law was applied correctly. There's a right to an appeal, going to the losing side in civil cases and the defendant if a determination of guilt was found in a criminal case. When they appeal, the government cannot appeal if somebody was acquitted of a crime, just so you know. Anybody know what the highest level of court in the United States is called? There you go, the U.S. Supreme Court. Okay, our U.S. Supreme Court currently has 9 justices. They could have more, depending on the Constitution or what the Constitution says. They hear about 100 to 150 cases a year from approximately 7,000 plus that are submitted. So it's very rare that your case is going to get heard in the U.S. Supreme Court. Cases can get to the Supreme Court directly from the federal level all the way up, or it can go from the state Supreme Court over to the U.S. Supreme Court. Okay? This is a losing party dissatisfied with the findings of the appeals court. In the civil system, the same thing. Either side can appeal. In a criminal case, it can only be the defendant who is found guilty. Okay, so what kind of cases are heard in these courts? Federal court also has criminal violations, like murder is a crime for both the federal system and the state system. It's probably unlikely that somebody who commits a homicide here in Tennessee, though, is going to be tried in a federal court. It's going to be, there's going to be a real good reason why that might happen. If, let's say, the person in state court was not found guilty, but they really feel like this person is a danger to society, the federal court can try that case without having double jeopardy being presented. Does that make sense? Because they're 2 different courts. Okay. But federal court's going to really kind of limit it to what I said before. Bankruptcy, crimes that cross state lines like drug trafficking and major financial fraud, crimes that directly affect the federal government, so counterfeiting, terrorism. When there's a dispute between states, those kind of cases will go to federal court. But for the most part, we deal in state court. Okay, so criminal cases, probate, contract, tort, family law, and juvenile. Bear with me as I turn the page. All right, so the most likely place you could be involved is going to be state court, like we said. How? How can you be involved in court cases, you guys think? A jury member. Okay, that's the biggest thing. And just so you know, in terms of state court, about 90 to 95% of cases actually get plea bargained out. So there's really a very, very small chance that you're going to be a jury member. So if you get asked to be a jury member, be a jury member. Okay, it's a super, super important thing to do. It's the most kind of civic thing that you can do, in my opinion, as a criminal justice professor. Other ways you could be involved in the court would be accused of a crime. So that means you're on trial, potentially. Victim of a crime. Witness to the crime as a civilian. You guys already said as a jury member. Testifying as a witness in your professional capacity and or as a lawyer, as the prosecution or the defense or any of the individuals who are on the table helping them with the case. So what's the process? Law enforcement gets the case, they build the case, they present their case to the district attorney's office, prosecutor determines if those charges are going to be filed, okay? The very first part is initial appearance. They have to go before the court within a reasonable amount of time, typically give or take 48 hours. And then the judge is going to rule on whether there's going to be enough evidence and what this court has jurisdiction, meaning that the court or the crime happened in its jurisdiction, that it can rule over. A couple different things can happen here. It can go forward to another formal stage. If it's a lower level crime or a misdemeanor crime, the judge might just kind of take care of a number of different things there, including assigning defense counsel if necessary. They could actually determine guilt, and sentencing can happen right in there if that defendant is willing to kind of waive some of their rights. Okay. Keep bearing with me. All right, the next level is the preliminary hearing. For those cases in which it was a warrantless arrest, I believe, the judge has to establish whether probable cause exists to suggest that this accused person is indeed likely the one that did the offense. Okay, so the judge can dismiss the case, meaning that they did not find that there was probable cause. The accused can also waive their right to a preliminary hearing, and case can get bound over for a grand jury for those states that have a grand jury system. The accused can also waive their right to a grand jury, and a prosecutor can issue an information, which is another term for indictment or charging. Okay. If it goes to a grand jury, evidence is presented by the prosecutor. That's it, by the prosecutor. So if a grand jury finds it sufficient to establish probable cause, then you have an indictment. Just so you know, 23 states and DC require a grand jury for certain crimes. 25 states make grand jury indictments optional. And 2 states have actually abolished grand jury indictments for criminal cases, except in special circumstances. The next step is the thing that you guys have seen on Law and Order, any of the other law shows that you might be watching, the arraignment, okay? It's often the first formal meeting of the prosecutor and the defense. This is where the accused is informed of the charges against them, advised of their rights as a defendant in criminal court, and this is where they enter a plea. Just so you know, like we talked about before, 90-95% of cases are plea bargained out, and those conversations are happening outside the courtroom, but prior to this hearing. So when they come in the court, if the defendant says they're pleading guilty, chances are they have gotten a deal for a reduced sentence or a reduced charge that comes with a reduced sentence. So you can do a guilty plea, a nolo contendere plea, or no contest, meaning that most likely the evidence is there that could convict them, but they're not saying that they actually did the crime. A not guilty plea, or not guilty by reason of insanity. A little tidbit there, less than 1% of court cases are actually not guilty by reason of insanity. That's the defense that's issued, and only about a quarter of those that are done or pursued are actually successful. Okay, so it's not, if somebody is thinking that not guilty by reason of insanity is the defense to go with, don't do it. No good. Okay. If the individual suggests that they are not guilty, then a trial date is set, and then that's what we see on TV. If there's a guilty plea, the sentence could be determined right there by a judge, or they can call for a separate sentencing hearing. All right. If it's a trial, typically only serious offenses are going forward. The defendant can be granted trial by jury, but they might request a bench trial. Anybody want to guess at what a bench trial is? There you go, the judge. Okay. All right. The judge is the determiner of guilt or not guilt. Okay. Prosecution and defense present evidence, cross-examine witnesses. A judge decides on issues of law, and then the result is an acquittal or a conviction on the original or lesser included charges. Okay. The next step can be a separate sentencing hearing, or it can happen right away. Judge or jury determines the sentence based on state guidelines. You could have presentation of mitigating, meaning reducing kind of the severity of the crime or punishment, or aggravating circumstances. They can be increasing the severity of the crime or punishment. The probation office or another designated authority often, or always, creates something called a pre-sentence investigation report. This is provided to the judge. It provides sentencing. Thanks, Professor. This provides sentencing recommendations, a background and history of the individual, and it also provides some sentencing recommendations based on risk and needs. Okay. Victims also have a part here. This will be my last little part. It's called a victim impact statement. And this is often read at sentencing. There is some controversy on that, whether it's going to sway a jury or a judge on emotional basis rather than on the law itself and the evidence that was presented. But that's the place where a victim can say, this is what actually happened to me and this is how it's affected me in all different levels. All right. Thank you for listening.